United States of America, USA President-elect Donald Trump will be no doubt the first ex-convict to become president in the North America country after Justice John Merchan sentenced him to no jail term and no fine unconditional discharge after the judge had last year found him guilty of falsifying business records and convicted him for criminal felony. Details of the judgment and other events that occurred yesterday at the court while Justice John Merchan was presenting the judgment is published in our audio and video versions of this news report. President-elect Donald Trump was sentenced to unconditional discharge for 34 charges of business fraud related to hush money payment to Stormy Daniels during the 2016 presidential campaign. President-elect Donald Trump was sentenced Friday morning in New York after the Supreme Court refused to block the sentencing, making him the first U.S. president to be convicted and sentenced for a crime to take office. Trump appeared virtually from Mar-a-Lago, according to local media, while others also reported that he appeared virtually for the sentencing at a courtroom in New York. Trump could have been sentenced of up to 4 years in prison but instead was delivered a sentence that does not include penalties like jail term or probation in what's called an unconditional discharge. An unconditional discharge, in legal terms, means that the person is convicted of the charges but is not punished further, such as with jail time, probation, or fines. Essentially, they are released without any conditions attached to their discharge. This can happen in cases where the court determines that the conviction itself serves as enough of a deterrent or punishment, according to local observers in the United States of America. Trump doesn't face any jail time, fines or probation, but his conviction still stands and he will enter office as a convicted felon, one of the observers added. The source news media reported that Judge Merchan emphasized that while the office of the presidency grants considerable legal protections, those protections do not diminish the seriousness of the crime. One power they do not provide is the power to erase a jury verdict, Merchan stated, acknowledging the citizenry's role in returning Trump to office despite the conviction. According to CNN, Trump, appearing virtually from Mar-a-Lago, maintained his innocence. "The fact is I'm totally innocent. I did nothing wrong," he said, calling the case a political witch hunt designed to damage his reputation. Trump also criticized Manhattan District Attorney Alvin Bragg, claiming the case was unwarranted and harmed New York's judicial system. New York states that unconditional discharge is when a defendant is convicted without punishment such as imprisonment, a fine, or probation supervision. While Trump expressed dissatisfaction with the outcome, his legal team views the sentencing as a step toward appealing the conviction. Despite his felony conviction, the unconditional discharge means Trump will face no further penalties directly tied to the case, allowing him to focus on his political agenda and upcoming cabinet confirmations, the source report ends in quote. President-elect Donald Trump on Friday was sentenced to unconditional discharge just 10 days before his inauguration. The case stemmed from accusations that he falsified business records to conceal a $130,000 payment to Stormy Daniels, who claims to have had an affair with Trump in 2006, a claim he denies, calling the prosecution politically motivated. Trump during the sentencing discussed his 2024 election victory, claiming he won the popular vote by millions and millions of votes and secured all 7 swing states, adding, "They've been watching your trial, so they understood it," referring to the voters. He also argued that legal fees were recorded by accountants as legal expenses, not by him personally. Legal fees were put down as legal expenses by accountants. "They weren't put down by me," Trump said. "It's incredible, actually."
Would your client like to be heard?
Yes, thank you, Your Honor. This has been a very terrible experience. I think it's been a tremendous setback for New York and the New York court system. This is a case that Alvin Bragg did not want to bring. He thought it was, from what I read and from what I hear, inappropriately handled before he got there. A gentleman from a law firm came in and acted as a district attorney, and that gentleman, from what I heard, was a criminal or almost criminal in what he did. It was very inappropriate. It was somebody involved with my political opponent. Part of the records that we're talking about, they're saying, I just noticed where he said I was falsifying business records. Well, the falsification of business records, as they said, was calling a legal expense in the books where everybody could see them, a legal expense. In other words, that legal fees or legal expense were put down as legal expense by accountants. They weren't put down by me. They were put down by accountants. I didn't call them construction, concrete work. I didn't call them electrical work. I didn't call them anything. They called a legal fee or a legal expense. And for this, I got indicted. It's incredible, actually. Now, if you look, my attorney alluded to it, the top legal scholars and legal pundits in this country, the ones that are quoted all the time on television, that are making their views felt and highly respected people, have said, everyone, virtually everyone that I know of, I haven't seen any to the contrary, not one, and none of these people are not exactly friends of mine, to put it mildly, but they all said this is a case that should have never been brought. It's an injustice of justice. Very respected Jonathan Turley, Andy McCarthy, Judge David Rifkin, a wonderful man who just passed away, by the way, Greg Jarrett, Ellie Honig from CNN, of all places. CNN said that. Paul Ingratian, Alan Dershowitz, they all said this is not a case that should be brought. It's not, think about it, legal expenses are down as legal expenses, and I get indicted for business records. Everybody should be so accurate. It's been a political witch hunt. It was done to damage my reputation so that I'd lose the election, and obviously that didn't work. And the people of our country got to see this firsthand because they watched the case in your courtroom. They got to see this firsthand, and then they voted, and I won and got the number of votes by far of any Republican candidate in history, and won, as you know, all 7 swing states, won conclusively all 7 swing states, and won the popular vote by millions and millions of votes. And they've been watching your trial. So they understood it. I wasn't allowed to use the lawyer-client privilege or the reliance on counsel. I had a lawyer that made this deal, and he admitted that. And he was also a totally discredited person. We weren't allowed to use the information from the Southern District that totally discredited him. It wasn't allowed to be put in. And that was terrible, unbelievable. And this is a man who's got no standing. He's been disbarred on other matters, unrelated, and he was allowed to talk as though he were George Washington, but he's not George Washington. He shouldn't have been allowed. The Southern District did a book of approximately 28 pages where I've never seen anything like it. They excoriated him. You wouldn't let it be put into evidence. So he was able to testify as a witness, and I think it's a disgrace to the system. I was under a gag order. I'm the first president in history that was under a gag order where I couldn't talk about aspects of the case that are very important. I guess I'm still under, so probably I won't do it now. I assume I'm still under a gag order. But the fact is that I'm totally innocent. I did nothing wrong. They talked about business records, and the business records were extremely accurately counted. I had nothing to do with them. Any of that was done by an accountant or a bookkeeper who I think gave very credible testimony and was corroborated by everybody that was asked. And with all that's happening in our country today, with a city that's burning to the ground, one of our largest, most important cities burning to the ground, with wars that are uncontrollably going on, with all of the problems of inflation and attacks on countries and all of the horrible things that are going on, I got indicted over calling a legal expense a legal expense. It was called a legal expense. I just want to say I think it's an embarrassment to New York, and New York has a lot of problems, but this is a great embarrassment. I believe that this and other cases that were brought, as you know, the DOJ is very much involved in this case. It's because that's the political opponent they're talking about. The DOJ is very involved. You have a gentleman sitting right there from the DOJ who was from the DOJ's office. He was also involved with the New York State Attorney General's case. And he went from there to here. He went around and did what he had to do. He got them to move on me. But in the meantime, I won the election in a massive landslide. And the people of this country understand what's gone on. This has been a weaponization of government. They call it lawfare. Never happened to any extent like this, but never happened in our country before. And I'd just like to explain that I was treated very, very unfairly. And I thank you very much.
Thank you, Mr. Trump. Mr. Trump, you appear before this court today to conclude this criminal proceeding by the imposition of sentence. Although I have taken the unusual step of informing you in advance of my inclinations, before imposing sentence, I believe it is important for you, as well as those observing these proceedings, to understand my reasoning for the sentence I am about to impose. The imposition of sentence is one of the most difficult and significant decisions that any criminal court judge is called upon to make. Our legislature sets the parameters for an authorized sentence, but it is a judge that must decide what constitutes a just conclusion to a verdict of guilty. A court is vested with broad discretion in determining what sources or evidence it may consider to arrive at an appropriate sentence. In doing so, the court must consider the facts of the case along with any aggravating or mitigating circumstances. In my time on the bench, I've been called upon to grapple with this weighty responsibility for countless defendants who have been found guilty after trial for an assortment of offenses, ranging from nonviolent Class E felonies to the most heinous of crimes, including homicides, sex trafficking, and child sexual abuse. The task is always difficult and deserving of careful consideration, whether the sentence be an unconditional discharge or incarceration of 25 years to life. However, never before has this court been presented with such a unique and remarkable set of circumstances. Indeed, it can be viewed fairly that this has been a truly extraordinary case. There was unprecedented media attention, public interest, and heightened security involving various agencies. And yet, the trial was a bit of a paradox because once the courtroom doors were closed, the trial itself was no more special, unique, or extraordinary than the other 32 criminal trials that took place in this courthouse at the same exact time. Jury selection was conducted, the same rules of evidence were followed, opening statements were made, witnesses called and cross-examined, evidence presented, summations delivered. The same burden of proof was applied, and a jury made up of ordinary citizens delivered a verdict. And it was all conducted pursuant to the rules of procedure and guided by the law. Of course, part of what made it feel somewhat ordinary was the outstanding work, preparation, and professionalism of the clerks, court officers, court reporters, security personnel, and the entire staff of this building who did their jobs as they would with any other criminal trial. So while one can argue that the trial itself was in many respects somewhat ordinary, the same cannot be said about the circumstances surrounding this sentencing. And that is because of the office you once occupied and which you will soon occupy again. To be sure, it is the legal protections afforded to the office of the President of the United States that are extraordinary, not the occupant of the office. The legal protections especially within the context of a criminal prosecution, afforded to the office of the President have been laid out by our founders, the Constitution, and most recently interpreted by the United States Supreme Court in the matter of Trump versus the United States, which was decided on July 1st, 2024. As with every other defendant in your position, it is my obligation to consider any and all aggravating and mitigating factors to inform my decision. Some of those aggravating factors have already been articulated in my Sandoval ruling at the start of this trial and by my recent written decisions on December 16th and January 3rd. Thus, they need not be repeated at this time. However, the considerable, indeed, extraordinary legal protections afforded by the office of the Chief Executive is a factor that overrides all others. To be clear, the protections afforded the office of the President are not a mitigating factor. They do not reduce the seriousness of the crime or justify its commission in any way. The protections are, however, a legal mandate which, pursuant to the rule of law, this court must respect and follow. However, despite the extraordinary breadth of those protections, one power they do not provide is the power to erase a jury verdict. It is clear from legal precedent, which until July 1st was scarce, that Donald Trump, the ordinary citizen, Donald Trump, the criminal defendant, would not be entitled to such considerable protections. I'm referring to protections that extend well beyond those afforded the average defendant who winds their way through the criminal justice system each day. No, ordinary citizens do not receive those legal protections. It is the office of the President that bestows those far-reaching protections to the office holder. And it was the citizenry of this nation that recently decided that you should once again receive the benefits of those protections, which include, among other things, the Supremacy Clause and presidential immunity. It is through that lens and that reality that this court must determine a lawful sentence. After careful analysis, in obedience to governing mandates, and pursuant to the rule of law, this court has determined that the only lawful sentence that permits entry of a judgment of conviction without encroaching upon the highest office in the land is an unconditional discharge, which the New York State Legislature has determined is a lawful and permissible sentence for the crime of falsifying business records in the first degree. Therefore, at this time, I impose that sentence to cover all 34 counts. Sir, I wish you Godspeed as you assume your second term in office. Thank you.
Osas Welcome Radio, bringing you the news in a more digital way.